Good morning, good afternoon, good evening, wherever anyone is. Thank you so much. And you know, with technology, if anything that can go wrong, there's a possibility that it will happen. I'm Roxy Nickel, and I will be your host for today. It is going to be my honor to be a part of this iNeutral digital launch. Allow me to welcome all our participants from Malaysia, Barbados, New York, Singapore, Ni Hao, Mauritius, Bonjour, Turks and Caicos, London, Miami, Richmond, Virginia, and right here in Jamaica. How do? Thank you so much for being part of today's program. It will include remarks from persons who know the importance, and you're all here who know the importance of a platform such as iNeutral. There will be a mini arbitration demonstration, which will give you an idea of how the disputes will be approached. And of course, the unveiling of the iNeutral logo and tagline. Well, we do have a tight lineup and we want to go straight into it. Let me extend especially welcome to the Honorable Delroy Chuck, Minister of Justice here in Jamaica, Sir Patterson Cheltenham, Chief Justice, Barbados, of course, Dr. Christopher Malcolm, Secretary General, Jamaica International Arbitration Center, Datuk Professor Sundra Raju, President of the Asian Institute of Alternative Dispute Resolution, Mr. Lloyd Distant Jr., President of the Jamaica Chamber of Commerce, Ms. Nicole Liverpool Jordan, Deputy General Counsel, Caribbean Development Bank. All other participants, members of the media, including our partners, Hype TV, Business Access TV, and of course, all the members of the organizing committee as well. So are we going to go right into it? We are going to start with the welcome by Professor Sundra Raju, President of the Asian Institute of Alternative Dispute Resolution, Malaysia. I turn it over to you, Professor.
Thank you so much, Your Excellencies, distinguished guests, ladies and gentlemen. I'm honored and privileged to deliver these introductory remarks at the start of this event, the unveiling of the iNeutral, the online dispute resolution platform for the Jamaican International Arbitration Center. I speak on behalf of the Asian Institute of Alternative Dispute Resolution, AIADR, as its president, and also as an advisory board member for the Jamaica International Arbitration Center. My heartiest congratulations and felicitations to the center for successfully organizing this event. And as I mentioned just now, participation from all over the world. It is an important and revolutionary milestone. It is also for the first time that Jamaica is representing the Caribbean, which has taken the lead in this area of expertise and application. Now, we all know the man behind this whole initiative. He's my very good friend and colleague, Dr. Christopher Malcolm, the Secretary General of the Jamaica International Arbitration Center. In his past life, he has been the Attorney General of the British Virgin Islands. Now he's the head of the legal unit of the Organization of the Eastern Caribbean States, an attorney at law, chartered arbitrator, also, more importantly to me, a governing council member of the Asian Institute of Alternative Dispute Resolution based in Malaysia. We first met in London at the Chartered Institute of Arbitrators England business and see how we have all moved on. Christopher, as I know him, is very passionate and is an energetic person in everything he does. And this is the base ingredient for success and greatness. Now, under his leadership, the Jamaican International Arbitration Center has become, in what a short period of 5 years since its inception in November 2005 as a not-for-profit company, the most active, prominent, and now I would say the most innovative of arbitral institutes in the Caribbean and perhaps in South America. It provides various alternative dispute resolution services under its own rules, such as arbitration, mediation, adjudication, neutral evaluation, and so on. Now, ladies and gentlemen, with the launch of this iNeutral platform, the Jamaica International Arbitration Center is committed to changing the game itself. The COVID-19 pandemic has ravaged all our communities. However, adversity and necessity are the parents of invention and innovation. There cannot be a more apt time to launch this I-neutral platform. The reason being is that the I-neutral platform is a unique technological innovation in online dispute management. It is ambitious that it aims to assist the resolution of domestic or international disputes between parties around the world. With this initiative, the Jamaica International Arbitration Center is arising above adversity, as this I-neutral platform application has the capacity to deal with both domestic and international disputes in accordance to various ADR procedural rules. Now, the real secret is that it is flexible to allow collaboration with other centers and institutes to use this same platform under their own ADR procedural rules. This is the long-term implication of this platform. With focused collaboration and marketing, I-neutral platform will become an important tool in resolving disputes between parties in a timely and cost-effective manner all around the world. While Dr. Christopher Malcolm will be able to explain better how it works, I'm aware that the platform incorporates a complete back-end management and hearing facility. It combines the various methods of ADR mechanisms under one platform. It is easy to use. It is based on a stable and up-to-date technological expertise. The registration process, as well as the delivery of the decision, will be completely secure online, ensuring privacy in accordance to Jamaica, which is in line with the global data protection laws. While it mimics the conventional dispute resolution mechanism, it is faster, convenient, and simpler, as it starts with merely filling up a standard form template provided by the platform. It also ensures that parties' rights are protected and will be directed with appropriate instructions if necessary, so that they are not rushed into making decisions or into a process that they are not ready for. The various tribunals and neutrals are able to work within the system and use their own developed system. I am delighted to confirm that the Asian Institute of Alternative Dispute Resolution shares the same vision as the Jamaica International Arbitration Center. We have agreed to collaborate and share the I-neutral platform as developed in Jamaica for use in Asia and Africa as we expand our reach into these two continents. Everything starts with ideas. Your hard work, commitment, passion has made this reality for use for our common good. I congratulate and commend the Jamaica International Arbitration Center and Dr. Christopher Malcolm for its I-neutral online dispute resolution platform. We look forward to making it available widely in Asia and Africa. Thank you so much and good wishes.
Thank you so much, Dr. Professor Sundaraju, who is speaking on the capacity and the unique innovation that this is, the I-neutral digital launch. And we look forward, as you say, to it being in Asia and Africa. Can we move on to Ms. Nicole Liverpool? Are we there? Liverpool Jordan, Deputy General Counsel of the Caribbean Development Bank in Barbados. Ms. Jordan, are you with us?
I'm here.
Thank you so much. Over to you.
You're welcome. Good day to everyone, and congratulations to the Jamaica International Arbitration Center on the launch of the I-neutral platform. An exciting day, no doubt, for the Arbitration Center and for parties who need assistance in resolving their disputes. Last year, at one of the Arbitration Center's Coffee Time webinar series, I spoke about the pros and cons of online dispute resolution. It has increased access to justice through remote and virtual technology. It is cheaper and faster. There is a notable reduction in backlog, and speedy decision-making processes are ensured. But on the other hand, in some jurisdictions, many issues persist, as claimants and respondents lack adequate skills to participate in the process, especially in developing economies such as the Caribbean, where there's an added difficulty of securing and maintaining expensive digital tools. So here at the Caribbean Bank, we are very keen to ensure that vulnerable people in the region benefit from the democratization of technology, that the justice gaps are closed and no litigant is left behind. So we look forward to the iNeutral web-based platform being used in a spirit of cooperation and as an easy to access and low-cost tool to empower people in the region to pursue early resolutions to their disputes and preserve relationships. Thank you.
Thank you so much, Ms. Nicole Liverpool. I must also note that during this event, you will be able to be given the opportunity. I know everybody was sent the link. You'll be given the opportunity to see how the iNeutral platform can and will be used. So you, during the presentation, you'll be able to open it and we'll be able to have a look and see how it actually works. We move on to remarks from Mr. Lloyd Distant Jr., President of the Jamaica Chamber of Commerce. Mr. Jr., are you with us?
Good morning, and of course to Christopher and to all of my fellow panelists and presenters this morning, and of course everyone who is listening in. It's certainly a pleasure for the Jamaica Chamber of Commerce to be here to acknowledge this historic moment. It is no secret that the Jamaican courts take much too long to deal with cases brought before it. It is also a very expensive process. What we know is that commercial disputes, when commercial disputes arise, dispute resolution, arbitration, and mediation can be relied on to resolve them as efficiently and as economically as possible. We also know that the COVID-19 pandemic has changed the world in a manner that we are now all aware. But every new situation creates an opportunity. And in this instance, we can ensure that we come out of this stronger, better, and more efficient. And to do that requires creative thinking, foresight, innovation, and investment. iNeutral is a testimony to all of these traits. Having in front of us a digital platform for online dispute resolution and arbitration is a huge step forward. The annals of Jamaica history are populated with stories of Jamaican businesses, especially small and medium enterprises that have been severely disadvantaged by a not very efficient legal system. Just unfortunate. But the JAIAC has provided a more efficient process for resolving disputes in the rollout of iNeutral. This platform is yet another innovation that will be of great benefit to Jamaican businesses and to Jamaican business community in general. What businesses should look at is that when doing contracts and agreements, include a clause that allows for dispute resolution, mediation, or arbitration services if a dispute or disagreement occurs. So we have been asking for that, and we'll continue to encourage that businesses do this. This will allow for them, and again, especially for the small and medium enterprises, a more cost-effective and efficient dispute resolution process. The platform, as we've seen it and we've viewed it, and we're very pleased to see it being unveiled this morning, it will facilitate this process in the scope of a new global reality, of this new global reality that we all face. So in this instance, the JCC is very proud to be associated with the JAIAC and the introduction of this iNeutral platform. I want to congratulate all who have been involved in the conceptualizing and creation of this, and urge all businesses and investors to embrace dispute resolution, arbitration, and mediation as their primary option for resolving disagreements. Again, thank you for this opportunity. Christopher and the team at JAIC, great job, and we look forward to supporting you on this going forward. Thank you.
Thank you so much, Mr. Lloyd Distant, Junior President of the Jamaica Chamber of Commerce. Thank you so much. And I know everybody would agree with you that we look for a cost-effective way of dispute resolution processes, and this will be one of those that will aid in that process. So we look forward to the launch and what it will do in the future. So we move into our keynote address. Our keynote address comes from one of Jamaica's well-respected political figures who has focused his attention as a commentator on social, political, economical, constitutional, and legal issues. Armed with his wealth of experience and extensive knowledge, it is in the area of the judiciary and the legal system that he found his passion and niche, thereby distinguished himself as an attorney at law since 1982. Consultant on the judicial system and legal aid in Jamaica, the author of many published papers on law and crime, as well as the author of 2 books, Should We Hang and Understanding Crime. Additionally, he has been a member of parliament for more than 20 years, serving the people of Northeast St. Andrew, and is the current Minister of Justice with the responsibility of providing a law-abiding society with an accessible, efficient, and fair justice system for all. Ladies and gentlemen, please welcome the Justice Minister, the Honorable Delroy Chuck.
Chief Justice of Barbados, Sir Patterson Cheltenham. President, Asian Institute of Alternative Dispute Resolution, DATUC, Professor Sundra Raju. Deputy General Counsel, Caribbean Development Bank, Nicole Liverpool Jordan. President, Jamaica Chamber of Commerce, Lloyd Distance Jr. Other distinguished guests, media representatives, ladies and gentlemen. I am extremely pleased to participate in today's launch of what is a unique and innovative online dispute resolution platform for the resolution of conflicts, which will enable persons to resolve their disputes or conflicts without having to engage litigation in the courts. Previously, after careful review of the system for the administration of justice in Jamaica, I came to the considered conclusion that the court system would be greatly assisted by complementary alternative dispute resolution mechanisms. Presently, I have become even more convinced that complementary ADR services are required if the need for timely and efficient outcomes is to be prioritized. I strongly believe that the alternative justice services is a major solution towards supporting the reduction of case backlog and daily heavy caseload in our courts, and also to address the underlying social issues which give rise to tensions, conflicts, and crime in our communities. Ladies and gentlemen, over the past year, I have been encouraging our judges to refer applicable cases to ADR, such as restorative justice, mediation, and child diversion programs. I have not stopped there. I have also urged communities to refer errant children to the child diversion program as we work closely with the Jamaica Constabulary Force and other justice stakeholders, such as our justices of the peace, whom we have been training as mediators and in RJ practices. Instead of seeking to resolve conflicts of their own or going to the courts, which oftentimes is a lengthy process, Jamaicans can access free services at our justice centers island-wide and peacefully resolve conflicts. Today's development is welcome and is a significant private sector-led step in the right direction. I believe iNeutral offers itself as an excellent complement to pathways to justice provided by the court system. Second, the niche to be developed by iNeutral is in sync with policy approach to the administration of justice, which is being pursued by the Ministry of Justice. Let me share with you some of the work that has been undertaken so far. A new Arbitration Act was implemented in 2017, which repealed and replaced the old Act of 1900. Jamaica signed onto the Singapore Convention on Mediation in 2019. Restorative justice, child diversion, and improvements to the physical infrastructure and operational readiness of the court system are prioritized. In addition, steps are now being taken to implement legislation to support mediation and facilitated contract renegotiation. The environment for the conduct of domestic and international ADR in Jamaica, including by reference to the legislative framework, is enabling and otherwise competitive. In closing, I'm especially proud to have learned that iNeutral has been developed by Jamaicans working in tandem with ADR and technology leaders from across the world. I intend to take the time out of my busy schedule to familiarize with the iNeutral platform. I've been advised that the system is user-friendly, and anyone, lawyer or not, technology savvy or not, can navigate it without difficulty. I highly commend the effort that has been made to develop and now implement iNeutral, and note that it could soon become a dispute resolution tool of choice in the public sector. I wish you a very entertaining and engaging conference.
Thank you so much. That was our address from our Minister, the Justice Minister, the Honorable Delroy Chuck. And we all look forward to this tool of choice that will help everyone navigate dispute resolutions on the site. So, as we said, we have a tight lineup, so we're going right into it. I now welcome remarks from Mr. Milton Samuda, Managing Director of Samuda and Johnson, Jamaica. Good morning, Mr. Samuda. Are you there?
Good morning, and thank you, Madam Moderator.
You're welcome.
My Lord Chief Justice, Honorable Minister, Secretary General Chris, President Raju, Chamber of Commerce Presidents, colleagues, distinguished ladies and gentlemen. Now, we all know that the internet has evolved from a place of merely multiple sources of information to a functional space where things actually happen and get done. The fascinating and continuing unfolding of e-commerce has fueled that functionality, opening up the possibility of more and more goods and services being delivered online. And colleagues, the services of dispute resolution are no different. And iNeutral is simply a pioneer, and it will not be the last, a pioneer in innovation in the emergence of online dispute resolution. For those involved in business and commerce, especially for micro, small, and medium enterprises, and for those involved in international trade, iNeutral and other forms of ODR yet to come will do several things. Firstly, democratize the delivery of dispute resolution, reduce the cost of dispute resolution, lend even greater efficiency to the processes associated with the resolution of conflict, make more convenient access to dispute resolution, and hopefully fuel legislative reform as the law, as it always has, seeks to catch up with technological progress. From an investment point of view, the availability of this type of service will also make Jamaica a more attractive investment destination based upon technological access to dispute resolution. Finally, because my brief look at the site shows exceptional functionality, user-friendliness, and ease of navigation, I really, really want to congratulate the Jamaica International Arbitration Center and Chris on a great innovation. It shows that in the Caribbean and in Jamaica, despite the restrictions of size and access and financing, innovation can live, breathe, and prosper. So I congratulate them on their continued forward thinking and path-breaking innovations. And I know this will be a successful launch and the uptake will be great.
Thank you so much. Mr. Milton Samuda, Managing Partner of Samuda and Johnson, Jamaica. And as you say, you know, we're Jamaicans, we are innovative. And whatever we do will rise, and we look as you say, innovation, we live, breathe, and prosper. So thank you so much. We continue with remarks from Ms. Janet Silvera, President of the Montego Bay Chamber of Commerce, Jamaica. She talks envisioned impact for the MSME sector. Good morning, Ms. Silvera.
Good morning. Thank you very much.
You're welcome.
Wow. Digital arbitration and MSMEs. In this fast-changing global technological economy, dispute resolutions as well have succumbed to change, and digital arbitration was born. So of course, it would be remiss of me not to encourage micro, small, and medium-sized enterprises to make use of digital arbitration in resolving commercial disputes. They quickly and conveniently resolve claims using online processes instead of more costly and time-consuming face-to-face meetings and hearings. And you have heard that from every other speaker that has spoken already before me. So what I'm saying to you is not new. But I want to congratulate Dr. Christopher Malcolm for his sacrifices, commitment, and dedication to the process. I have watched Dr. Malcolm since the day he launched JAIAC, when arbitration became his personal addiction. It is a good thing to be addicted to, Christopher. I'm really very proud of you. Digital arbitration has the potential for providing consumers with convenient and cost-effective access to remedies while augmenting MSMEs' cost savings from avoiding court and class actions. There's a vast amount of benefits also to be garnered from digital arbitration, such as remote participation, as you know, which provides the ability for parties, legal team members, technical experts, and even panelists to fully participate in arbitration proceedings. Look at where some of the people are coming from on this event this morning. All the panelists are coming from other parts of the world. It gives us the opportunity to even be able to do this from remote locations, and it is very cost effective and as such very convenient. The proceedings are now paperless. The fact that electronic meetings mitigate the logistical complexity of the hearing process, which speeds up the normal resolution time, is very, very encouraging. It increases security for sensitive material, and it enhances collaboration of MSMEs and consumers. I can only say at this time that we could not have asked for a better thing. Congratulations on unveiling iNeutral and showcasing that Jamaica is always first, always ahead. And we should be congratulated for what we've been doing. Thank you.
Thank you so much, Ms. Silvera. That is Janet Silvera, President of the Montego Bay Chamber of Commerce. As she said, always ahead, which is what we do, and we do it as a team. More remarks coming from Mr. Walter H. Scott, QC, attorney at law in Jamaica, who will talk about impact for legal practice in Jamaica. Good morning, Mr. Scott.
Hi, good morning, Madam Host. Madam Host, the Honorable Delroy Chuck, QC MP, Minister of Justice, Sir Patterson, gentlemen. May I first of all offer my sincere congratulations to Dr. Christopher Malcolm and the Jamaica International Arbitration Center Limited on the conceptualization and subsequent execution of the iNeutral online dispute resolution platform. Dispute resolution has been the one area of the practice of law that has proved to be most resilient during the COVID-19 pandemic. The courts of Jamaica, led by a Chief Justice who has an agile and technological mindset, have been able to pivot to the new dispensation. Much more could have been achieved if the funding were available. But alas, the public purse was required, quite properly, to ease and ameliorate the awful consequences of the effects of the pandemic on the lives and livelihoods of Jamaicans. It is within this context that iNeutral has arrived. Every seismic change in history has a forerunner, whether it has been religious, economic, political, or otherwise. It is my considered view that iNeutral is the forerunner of the fully digital legal platform for the courts. 36 years ago, when I commenced practice, the leading bits of technology for lawyers were the telex machine, the Gestetner machine, and the Xerox copier. 36 years later, lawyers in Jamaica who wish to access a fully digital platform for all types of dispute resolution matters except court proceedings may do so utilizing the iNeutral platform. Without giving into a natural disinclination for hyperbole, it is simply awesome. In a few minutes, you will get a demonstration, which I have no doubt will make apostles of you all. End-to-end, completely digital dispute resolution, complete with rules and transcripts, is revolutionizing the legal services industry in Jamaica. The Jamaican and Caribbean dispute resolution systems will never be the same. Again, congratulations on this launch.
Thank you so much, Mr. Scott. Just to remind all our participants that we will have the arbitration later on, and the link to the arbitration has been placed in the chat. So when we get to that, you'll be able to access it from the chat. Now, as you all know, and to all the other participants on iNeutral, is an online dispute management platform that develops full spectrum application capacity for dealing with domestic and international disputes. And we will now see what it looks like. And to give you the technical overview, I welcome Mr. Ryan Davey, Managing Director, XR Studio in New York. He will explain the end-to-end solution, but we will see the unveiling of the logo. So keep looking at the screen and you will have a look at the logo, Dispute Resolution Made Easy.
Seen the website?
Yes.
All right, perfect. Okay, so welcome. This is the homepage of the website. You can see it gives an overview of our services. Also gives an overview here of some of the features and standard features and optional features. Okay, so we're gonna go on up and we're gonna start the process from someone new that's just coming on the site. And let's just say they wanted to hit get started. They could go ahead and hit get started. And the first thing they would do, they would go ahead and register. Now for the demonstration purposes, I do have a demo button here, so we could just breeze and skip right through. So they'll go ahead and register. And after registration is completed, they will then be greeted with the dashboard. Now from this dashboard, they can go ahead and they can file a claim. They can view the previous claims that they filed before. They can reach out to support. And they can see the history of the claims that they submitted before. So let's go ahead and file a new claim. Here we can select the service that we're requesting, whether mediation, arbitration, whatever the service is. We can select if it's a domestic or international matter. We can do individual or corporate. Corporate will then, ask for a company name. Individual, it will shift for you and just, ask for the person's name and stuff, and you can enter all of that. All right, so let's go ahead and scroll on down, and they will go ahead and fill out all this information here. All right, now here they can fill in a little bit information about the dispute. They can type whatever they need, and they could go ahead and upload any documents. And also, if they have their documents on Dropbox or a Google Drive, they can put the URL here to whatever the service is, you know, whether it be like Dropbox or whatever service, whatever the URL is for the file that they want to send. Let's go ahead and proceed. So they'll submit that. And again, I'm just skipping through the demo button. And they'll receive a notification here, lets them know that the request has been submitted to the JAIC. They will also receive an email confirmation with that. And now the JAIC will be able to review all of the information that was submitted. So once all that is submitted, the JAIC review and say this is something that, you know, we're going to move forward with. The JAIC would reach out to the individual or the company, whoever submitted it, and say, okay, we're ready to get started. And let's see, let's move forward here. So once they're ready to get started, they're now able to select the arbitrator. So these are some of the arbitrator that I have here, and they could select which one they wish to use. They could also put in a request to use someone else. They can also do that if they wish to use someone else. And all the parties will have to, you know, agree on who they want to use. So if we go ahead and select first one here, you can see that this person is selected or voted because all the parties will have to agree. And once that is settled upon, we'll be able to move forward. And then this will bring us right into our claim. So this is where all the parties would, once the claim is started, they will enter here. And if they have multiple claims, they will see the multiple claims all listed here. So we'll go ahead and then we'll just enter one. And these are all the parties. So whoever is inside of this claim, they have access to it. So these two people here, they only have access to this unfair dismissal. These people over here, they only have access to this construction matter. Okay. The reason you're seeing multiple is because I'm in as an admin. If you were this person, you'll only be seeing this particular claim here. All right, so let's go ahead and go inside unfair dismissal. All right. So once we're inside of the claim, from here, we can go ahead and let's just say we wanted to request some documents from one of the parties. We can say, send me some documents, right? And then here we can select the person. We can say we want Richard to send me these documents. Oops, and we want it by a certain date. We can select here and select the due date, you know, or we can even select a range if we wanted on there, you know, if we wanted to even pick a range. So between May 13 to 17, I need you to send me some document. I could go ahead and add that. Once I add this task in here, he will automatically get an email saying, you know, whatever I wrote, saying to send me this document here. All right. So also, so this is how the arbitrator will be able to correspond with the different parties and set due dates on whatever documents they may need. There's also open discussion. In this discussion, all the parties within this claim, they can start a discussion and they can, you know, have an open discussion here. There's an overview. The overview is pretty much a timeline of kind of the events of what's going on. We'll have how many discussions going on, how many tasks, how many comments, how many files, and then we also have milestones, which you guys can set milestones. Similar chart here, which would kind of, you know, give you a list of what's going on. You know, see, these are I just put send documents and stuff. So these are all the tasks here. I can see the due date. I can see what needs to be delivered by which party at which time. If someone needed to upload a file, they could simply click here and they could click upload, in which they could go ahead and upload a file here. And if any file that's uploaded is by default public to the group. If they wish to make this private, they can check private. And once it's private, only in this case, it's an arbitration. So only the arbitrator and the JAIC will be able to see this file that's marked private. Okay. There's also a calendar here, which would, kind of give you an overview of what's going on. See, this is the send doc that I put in. That's the timeline in which we need it to be delivered. And if we go back to claim here, let me just go back in. If they wanted to start a Zoom meeting for all the parties, you could literally tag everybody if you wanted, and then you could put the URL here to whatever the Zoom link is, and you can set the date for your Zoom. So this is live Zoom meeting. And then you put the URL. For now, I'm just putting in Zoom, right? And it will go ahead and add that. So once this is added, again, everyone would automatically get an email. System will send it out. We have a live Zoom meeting on this date. They could come here, they could click on it, and they could go to that meeting. All right. So once a decision is made, the arbitrator would go ahead and they would issue an award, and they can do that from here also and send it to the parties, and they can post whatever file, like the award or whatever file that they need. They can go ahead and post that up in here also. Let me see here. So guys, that is the bulk of the arbitration process, and the similar process for, if you're doing a mediation and so forth. All right. So with that being said, I'm going to show you two things that's more back end that the clients would, or they would not see. So the people who are submitting claims, they would not be seeing these two things that I'm about to send you or show you. So the JAIC will be able to keep track and progress of what's going on. So the JAIC will have access to this progress here. They'll be able to see the dates, everything that's going on within a claim. They'll also have reports, and they can run reports, and we can export Excel reports of anything that's going on. So all the activities are tracked, and we can actually run reports on everything. All right. So one of the next thing I'm going to show you guys is that we have a lot of different forms that could be pulled up. So let me go over to the forms here. I'll show you how that is tied in. Just pulled up my form page. Just give me a sec. I'm just going to switch it to this screen. So here, we're in an arbitration. We've set this Zoom meeting here. We have this, and now we want to, let's just say we need this person or a person here, Richard, here to fill out a specific form. Okay, the arbitrator can jump into our form section, and they could go ahead and just literally go through a lot of pre-built forms that's already built out. We can also view any of these forms. I'll just pull one of this up. Okay, this is one of the pre-built forms, one out of many. It's So there's a lot of different forms in here. You can also, they can put their signature here, and they could select the date, you know, when it's time for them to sign. And then we have different categories. This one would be for neutrals, mediators. And there's plenty of different forms in here that the arbitrator can go and pull out. So again, we could pull out a different form, and you can see here, procedural order. You could, or you've not seen the forms. Let me, hold on, let me see here. Oh, it's in my window. Okay, you guys seen the form page now?
Yes, yes.
We can see it, yes.
Okay, okay,
I see
okay.
it, yeah.
Yeah, just, yeah. I have multiple windows and I have this Zoom set on a specific window. So just let me know if you're not seeing anything. Okay, so back to what I'm saying. So the arbitrator needs to pull out a specific form. There's a lot of pre-built forms that we have in the system here. So if I was to click, let's just say I was to click view here and open one of these forms, you can see this one here. This is a form here for mutual agreement. They can go ahead and fill out the form. You know, once all of this is filled out, there's also, I'll show you another one here that has a signature. Hold on. Pull one of these up. Let's see. Let's have a signature one. Okay, here we go. Yeah, so they can view and preview all these forms before they send it to someone. So the arbitrator, I'm an arbitrator and I'm just, all right? So I'm literally looking at this form, and once you send it to the person, they can click the date in which they sign, and they can put their signature right here on the form. And they could go ahead and submit, okay? And once they submit, we automatically get this form on our back end, and the person would also receive a copy. So I can simply copy link, come back here to my, this is my arbitration here with all my parties. I can say, hey, Richard, I need you to fill out this form. Simply put the link. There we go. Our task is created. He'll automatically get an email, and he can go ahead and fill out this form. And just like before, I can also put a due date on that. So, and once he fills this form out and this is done, I can go ahead and I can just mark this as completed. I could check that. And now that's completed. I've now, that task is completed. I've received that information. If he sends this document, I can check that off and say that is done. And here we can also see the due dates, right? You know, I'm waiting on a document here. This is my due date. I'm still waiting on that, all right? So that is pretty much an overview walkthrough of the system and the flow. Let me know if you have any questions.
Ryan, I am sure I can echo everybody's sentiment that this is a fantastic site. It is quite user-friendly, and I am no arbitrator yet, but I see that there's a lot that we can utilize on it. So everybody, a resounding yes on the website so far? Yes.
Yes.
It is. Okay, good. A round of applause. All right. It's a lot of hard work to put this together. You can unmute your mics and give them a round of applause. This is incredible. We'll have more later on. So at this point, we go right into remarks from Mr. Anil Changaroth, Managing Director, Changaroth Chambers, LLC from Singapore. He will highlight the maturity and expansion in Asia, linkages being forged, and the possible impact of iNeutral. Mr. Changaroth, are you there?
Yes, I am. Thank you very
Welcome.
much.
You're welcome.
Thank you very much. Incredible. What we just saw was quite incredible, and let me explain why. I think the starting point is the fact that we are indeed in a new global reality arising out of the COVID-19. And as the Honorable Minister said, that complementary ADR mechanisms are absolutely necessary. And here we have an example. We're talking about, you go into the platform and you see mediation, you see conciliation, you see neutral evaluation, you see expert determination. I have for several years now said that it's no longer alternative dispute resolution, but appropriate dispute resolution. And that's what this platform is doing. My experience with ODR comes from 2016 when I first published an article in the Asian Journal of Mediation talking about ODR. And then I had gone on to work with the Asia Pacific Corporate Cooperation, Economic Cooperation on a ODR protocol that's gone international as well. And I've worked with several other organizations, companies that have got platforms. And the problem I've always faced is the fact that when you first get onto the platform, you have no idea where to go and where to start and where to move down the line. Whereas here with iNeutral, it's so simple and easy and straightforward, and you get the option of looking at different dispute resolution mechanisms in place. And then when you get on to the next page and the next page, it's very simple and straightforward. I've had experience sitting as both an arbitrator and mediator on matters online, and I find it very difficult. At times, it's not as user-friendly, and I end up having to get off the platform and speak on the phone. So I think it's what Dr. Malcolm's done with the team and what you guys have done out there is incredible. We here in Singapore, as you know, just a couple of weeks back, it was announced that the Singapore International Arbitration Center had crossed 1,000 cases, all right? And the Singapore Convention that was signed 2 years ago. So it is prime to see all of this move on an online platform. And I think we can take a massive cue from Jamaica on how to do it right. And moving forward, I think it's an incredible platform. And if you get to see that work domestically and internationally, I think it's going to be quite incredible. Thank you very much.
Thank you very much for sharing your words with us, Mr. Anil Shangarath, Managing Director of Changarath Chambers in Singapore. And we now move on to remarks from Ms. Christobel Brown, Operations Liaison at We Pay Jamaica. Good morning to you. Over to you.
Everyone here, good morning, good afternoon, good night. I believe the time difference is different. So with all protocols observed, let's get straight to the point. We know that online and e-commerce is a big hell of a thing. And we understand that you can have a website, whether it is for arbitration or any other industry, but to make a website get payments is where you become e-commerce. We do understand here as well within Jamaica and the Caribbean, there's a difficulty in terms of getting monies to your local bank account, whether it's local or even international currencies. And this is where We Pay comes in. I'm really happy that Dr. Malcolm reached out to us to, of course, ensure that we get the payments from his website to bank accounts. That is one of our main priorities. But again, even though you have the payments coming to you, there's also privacy and safety and security about your monies, about your card information. And of course, we're living in a real digital society where that is prevalent. Card fraud, persons copying a card, etc. So of course, We Pay is PCI compliant and FISERV compliant to ensure that all of your monies, all of your card information, it's safe, it's secure, it is protected. So at no point in time, we will ever share your information. I'm also pleased that once we go, well, I didn't think Ryan reached that part in the demonstration, but once you check out, it will reach to the point where it's hosted by our partner bank, First Global, and I'm really happy that they're on board to ensure that, again, all monies come home. Not anywhere else across the world, right here in Jamaica. So even though we are a Caribbean company, we're ensuring that Jamaica, of course, is setting that trend and ensuring that right now with this digital arbitration solution of iNeutral being the first of its kind within the Caribbean, we are, of course, really pleased to join with this team to ensure that we set the trend for any other solution within the Caribbean. So I'm really pleased to see all of you here. We want to ensure that all of these payments are going to be secure, whether it's in Jamaican currency or USD currency, and we're pleased to ensure that every single payment is safe and secure with We Pay. Thank you, everyone.
Thank you so much. Christobel, you know, we're doing more than one thing at one time to ensure that we run smoothly. I would like to apologize for the absence of Sir Patterson Cheltenham. He is caught up in a court matter, so that's why he was unable to make it to us this morning, but he sends his wishes to us as well. Thank you again. So remember I had said earlier that we would be looking into iNeutral, how to make it easy. And in the chat room, so I now direct you to the chat room for the stay on Zoom, don't go anywhere, but I'm sending you to the chat room because we're gonna have the mini arbitration for a construction project dispute. So please, I direct you to the chat room because the link should be in there for you to access, and it will be real-time notes. So whatever is being asked, whatever is being done, you will see in real time. So let me know if you've made your way in and you are able for us to begin the mini arbitration dispute. I turn this over to Karen and her team, who will be showing us the mini arbitration intro.
This is the arbitration demonstration. So I'm Karen Goff. I'm going to be the arbitrator in the demonstration. This is a fictional dispute between Kitco Chemicals Limited, who is claimant, and the employer company under a building contract, which engaged Competent Contractors Company Limited, the respondent, the contractor for the works. Very straightforward. The dispute concerns the construction of 2 fuel storage tanks sunk in the ground. One developed a serious fracture and there was leakage of fuel, which may or may not have been the cause of contamination to the water supply of adjoining farmers. The contract is the standard form of building contract. It's a design and build contract, which means that the contractor designed the works to the employer's requirements. The design might, however, have been compromised by limitations imposed by the employer's requirements. So that's the outline of the dispute. Counsel for the claimant is Professor John Rooney from Miami. John, wave your arm, say hello. And counsel for the respondent is Mr. Calvin Hamilton from Barbados. Now, procedurally, the parties didn't agree a procedure. So as arbitrator, I imposed one. It is very tight. Each party has a very limited time to make its submissions. The time is to be shared equally. We ask you to assume that the hearing is already part heard. We have in the witness box ready for cross-examination Ms. Sherika Lindsay, who is the Chief Executive of the claimant company Kitco. Mr. Hamilton, for the respondent, is to cross-examine the witness. Please continue, Mr. Hamilton.
Good morning, Ms. Lindsay.
Morning, Mr. Hamilton.
Can you hear me well?
Yes, I can. Can you hear me?
Yes, I can hear you perfectly. We're going to have a little chat about your role as the CEO in this project. And essentially what we're trying to do is to get to those facts that would help the arbitrator to make a decision. Is that all right?
Okay, I understand.
Splendid. Now I note from your statement, and do you have the statement before you?
Yes, I do.
And have you reread it?
Yes, I have.
Is there anything you want to change in that statement?
No.
So you stand by those affirmations?
Yes, I do.
Terrific. All right. I note that you have an LLB in civil engineering. What is that? Are you a lawyer or are you an engineer? What are you?
I am neither a lawyer or an engineer. It is my first degree. You can say I was exploring at the time.
Okay.
My master's is in business administration.
Okay.
I am an business exec by profession.
Okay. All right, terrific. I'm going to ask you, because of the time constraints, just to briefly respond to the questions, all right?
Okay, okay.
Okay, terrific. You say you negotiated the contract with competent contractors for the design and build of the gas station and the fuel tanks. You're familiar that the FDIC Yellow Book rules were also incorporated by reference to the contract. Do you know?
Yes, it was.
Terrific. Competent contractors say that Kidco told them that they wanted to save money in the contract and that competent contractors did not need to carry out soil investigations and need not price for it in the contract. Is that correct?
Can you repeat the question, please?
Yes. Better, can the transcriber, would he be able to put the question up on the screen so that you may have the benefit of it? Yes, so there it is at 11:15:52. Competent contractor says that Kidco told them they have to save money, and as a result, there was no need to carry out the soil investigations.
Yes, that's correct.
Okay, terrific. Isn't it also correct that competent contractors' tender was based on stated assumptions on the soil formation?
I did not get that impression during the negotiation.
All right. If you go to your statement at 12, paragraph 12 and paragraph 10 to some respect, you state that indeed certain assumptions were made.
Yes.
Okay. So there are certain assumptions were made during the negotiations.
Yes. That's
Terrific.
the soil conditions.
Okay. And when the contract was signed, you were aware that those assumptions were the basis, formed part of the basis for the contract?
Yes, it was.
Good. It is a design and build contract. So while competent contractors prepared the specifications for the tanks, isn't it not correct that Kidco provided the specifications for the steel to be used?
Yes, we did specify the steel to be used.
Okay, all right, good. Can I have put up on the screen a design or a description of the soil formation and where the tanks are located for the benefit of the witness? Can you put that up for me, please? Splendid. Okay. Ms. Lindsay, do you see that display?
Yes, I do. And as you can see, the tanks are in the brown color. It is 15 feet below the surface and in mostly sandy material.
And so the tanks were placed within 1 to 15 feet from the surface.
That's correct.
All right. And that sand formation continues to about 20 feet in the soil formation. Okay.
Yes, the sand went down to 20 feet.
And that's the western side, isn't it?
Yes, it is.
And the farmers and where they access the water from aquifer is on the eastern side. Is that correct?
Yes, and that's 40 feet.
Right, and they go down to about 40 feet.
That's correct.
Well below the 15 feet where the tanks were located on the eastern side.
That's correct.
And is it not true that there were no investigations done with respect to the soil formation?
Not that I'm aware of.
Okay, and is it not true that the CCL received instructions that in the event that it was not needed, that no such investigations should be incurred, and the price the price benefit should incur to Kidco?
Yes, if the investigation was not necessary.
Okay, okay,
yes.
Terrific. And so the dispute and the leakage came to light after or during the period of final reception. Is that right?
That's correct.
Okay. So that prior to that, the construction, the materials were all done according to specification.
Of Kidco.
I'm sorry? Specifications received from Kidco. Yes, that's right.
Yes, yes.
Okay. And at no time did KIDCO inform competent contractors that their assumptions for designing and building out the station and the tanks were incorrect?
That's incorrect. We did inform them that it was untested.
Yeah,
Mr. Hamilton, you're almost out of time. Can you make this your last question, please?
Yes. Stay with me, Ms. Lindsay, because if we, as you stated, competent contractors were working under certain assumptions which were not corrected, and they were never corrected.
No.
Okay, that's my final question. Thank you.
Many
Thank you very much, Ms. Lindsay.
Mr. Rooney, any re-examination? You need to unmute.
Yes, I'm sorry. Madam Chair, I do have some re-examination, but it will be brief. Ms. Lindsay, good to see you again. Hope you're doing well.
Hi, Mr.
I just have a couple of follow-up questions. One concerns the question of the obligation to conduct tests on the underlying soil of the works, and also what other consequences that might have entailed. What I understood Mr. Hamilton to have said is that there were certain assumptions that were discussed between the parties with respect to soil quality and the possible need to do boring. Is that correct?
Yes, that's correct. Go ahead.
My question is a little more specific than that. Regardless of whether there were assumptions, did those requirements find themselves into the written contract?
No, they did not.
So the written contract did not, any assumptions that may have been discussed with respect to the quality of the soil did not actually form part of the contract. Is that correct?
Oh, no, the assumption did not form part of the contract.
So would it be the position, would it be the position of KIDCO that the contractor, in the faithful execution of its duties and obligations under a design and build contract, should have undertaken that examination?
Yes, because the discussion was that if the test was necessary, they would have carried out the investigation.
In the expert testimony provided by competent contractors, the expert basically said, implies that there would have just been one bore at the site and that there would not have been borings down the line, and that bore really would not have told them anything. Is that,
Professor Rooney, if I may just, I really don't see how a witness of fact can assist you with an expert opinion.
I'm sorry, I was not asking her really to assist me. I guess what I was saying, what I'm still trying to determine is, it appears to be the respondent's position that they only had to place one bore, basically. That was all.
Sorry, complete your question.
Okay, and so the question is, in your reading, would the contract have limited in any event the contractor to only conducting one bore of soil?
No, they were not limited. The discussion was that they would perform the necessary investigation. If it was up to them, being the industry and the prudent and industry professional, to determine that. So they were not limited. We guess we wanted to save money, but not by being penny wise and pound foolish.
Understood. Let's see then. One final question. You had said that you are not an attorney. Is that correct? Or you are?
I'm not.
I assume that your company had attorneys that participated in the negotiation of the contract.
Yes, we did.
Okay. So okay, no further questions, and thank you very much.
Thank you.
That concludes the fact witnesses then. So let us hear from the experts. We assume the expert for the claimant has given evidence, and now we are hearing from the expert for the respondent, Mr. Jade Lindsay, an engineer. Mr. Lindsay will be cross-examined by Professor Rooney. Professor Rooney, please continue.
Thank you very much, Madam Chair. Mr. Lindsay, how are you?
Today I'm doing well. And you?
I'm fine. I'm fine. First, thank you for your participation in the arbitration. Have you given testimony before?
No, I haven't.
Okay. There are just a couple of formalities that we'll go through first, and then what I will do is take you through certain parts of the report and ask you questions and clarifications, etc.
Okay.
The first thing I would like to state is that even though that you are an expert provided by a party, that you nevertheless are independent with respect to the opinions that you provide, and that you are provided for the purpose of assisting the arbitrator to make the correct decision in this matter. Do you understand that?
Yes, I do.
Okay. Do you have a copy of your expert witness statement before you?
Yes, I do have a copy.
Can you verify, if you could could you verify that the report shown on the screen is in fact your expert witness statement?
From what I'm seeing on the screen, it is.
Okay, and that in fact that you have signed that statement?
Yes, I did.
And you attest to the truth and correctness of everything that is contained in it, correct?
I do.
Do you have any additions or corrections to make to your statement at this time?
Not at this time, no.
So you would consider the report to be complete?
Yes, I would. I would consider it so.
You were instructed in this matter by Hamilton Abogados, the attorneys for the respondent, correct?
Yes, I was.
And I assume you've received a fee for the preparing of your report. How much have you been paid, or will you be paid for your services?
I would be paid a sum befitting my experience, a reasonable sum, I think.
Can you be more specific?
More the exact figure?
Yeah.
I'm paid roughly 50,000 for my opinion.
Okay, is it by the hour, or is it a flat fee, or?
It's a flat fee.
Okay, and is any part of your compensation contingent on the result of the case?
No, it's not.
Okay, you had said that you had not testified in the past. I assume you are an active professional in your field.
Yes, I would consider myself so.
Do you have any affiliation with an academic institution?
Not at this time.
Okay. I note that you don't reference any articles that you may have published in this area. Have you not published any articles in this area?
I don't consider myself to be an academic. So to answer, no.
Okay. I assume, however, that you do rely on academic sources in terms of establishing standards, et cetera, of conduct and et cetera.
Yes, we're appropriate.
Okay. What would you consider to be the single most important academic text in the technical area in which you have provided evidence?
I don't believe we have a Bible of sorts. It's more appropriate to consider appropriate literature depending on the circumstances and the issues at play.
Why did you not cite any academic support in your report?
In the present circumstances, it was not necessary. I considered the information provided to me, and based on the joint expert report, also based on the expert report prepared by the claimant, that those were sufficient for me to form an objective opinion.
Okay. In which country is the...
Professor, you have 2 minutes to get to your point.
Yes, ma'am. In which country is the dispute located?
It is situated in Jamaica.
Okay. And I understand you did not conduct an on-site examination of the work. Is that correct?
I didn't believe it was necessary.
In Article 5 of your report,
yes,
your reference to the standard for the undertaking of soil borings or ground investigations is not supported by any independent sources. Are they?
No, they're not. I don't believe there are any particular standards appropriate. Soil borings are generally simply borings taken of the soil, and depending on the purpose of the works, there might be different tests that would meet appropriate standards based on what is being done. So
There's no
no.
professional or academic context in which you determine whether or not that would be necessary or not. Could
you repeat that for me, please?
So there's no academic or professional standard that would indicate.
No, there isn't.
Okay. And then in paragraph 8 of your report, you state that all reasonable precautions were taken in the construction of the tanks. But once again, you do not cite any professional sources to support your conclusion, do you?
No, I did not. I based my conclusion on the as-built designs, and based on what I saw, I believe the contractors took all appropriate steps, which included encasing the tanking in concrete.
Okay, we'll get to that in the next point, which is paragraph 9. In paragraph 9, you state that the reviewed designs, calculations, and as-built record conclude that all fall within acceptable parameters. Yet you did not attach to your report the documents that you reviewed, did you?
No, I did not.
And once again, you did not cite support in the literature for any support as to your conclusion as to what the acceptable parameters are, do you?
No, I did not.
Okay. In paragraph 10, you state that you commissioned laboratory tests of the water samples taken from Hope Water, but you do not attach the results of the test to your report, do you?
I do not, but I believe these are in evidence nonetheless.
Okay. And I would also like to once again put up on the screen the slide. I think it is slide number 9, I believe. Wait a second for that. I don't know, you may not have seen that. I don't know if you saw Miss Lindsay's testimony or not.
Yes, I did. I saw it.
The question is, if you look at this dynamic, would you consider this to be an accurate representation of what you now understand the characteristics of the subsoil to have been?
It gives a general description of how the subsoil will look. If you appreciate that the substrata is not divided in fixed lines as demonstrated on the image here, but it's sufficient for our purposes.
Okay, and then lastly, there is another slide that I would like to be shown, which would be the slide showing the damages that are claimed. I assume that in review of the file, you probably have seen this.
I have seen it, but I'm not a quantum expert, so I can't comment on the accuracy of the calculations.
Okay, okay. So in closing, then you do ratify the conclusions set forth in your report?
I do.
Okay, no further questions.
Thank you, Professor. Thank you, Mr. Lindsay. That concludes your evidence, unless, of course, Mr. Hamilton, you have any re-examination? Would help if you weren't on mute.
I'm sorry. Yes, if you'll indulge me, I'd like to redirect the expert, if you will. Is that all right?
Mr. Hamilton, you've got 2 minutes.
Thank you. Did you review the documents in the file making up the complete file for this arbitration prior to preparing your statement?
Yes, I did.
Thank you. Does the mill test certificate show that the steel used to construct the storage tanks was at least 40% weaker than should have been used?
Yes, it does.
Thank you. Did you hear Ms. Lindsay's evidence?
Yes, I did.
She says Kitco was responsible for the specification of the steel. Did you hear that?
Yes, I did.
Okay. From your review and inspection of the evidence and site, were you able to come to any concluded view about whether the cracks in the tank were as a result of poor workmanship or instead by latent defect in the specified steel material, or that they resulted from unstable surrounding ground conditions?
Based on my review of the information on dates and design,
the contractors took all appropriate steps, and I do not believe in the circumstances that the cracks in the tank were attributable to the contractors.
Thank you. Do you have a view as to what caused the contamination?
Well, in my opinion, based on the surrounding circumstances, it is likely that the contamination was either caused by leakage due to latent defects in the tanks or from the adjoining Hope River, which runs perpendicular to the site and the Trent community.
You did a lab test which concluded with some findings, did you not?
Yes, I did.
The findings of that lab test, did it show that there were additional contaminants out beyond the petroleum that was leaking?
Yes, it did. It showed that there were fertilizers and chemicals commonly used in the farming industry present in the water.
So does that mean, or could it be interpreted that there were more than one possible reason, there was more than one possible reason for contamination?
It's possible.
Okay. And finally, just, are you aware of any specific reports in the public domain that describes the soil formation in Jamaica, particularly in the site that we're talking about?
No, I'm not.
Thank you. That's all, Madam Arbitrator.
Gentlemen, thank you very much. Can we go straight into closing submissions? Mr. Hamilton, you've got 3 minutes.
It is clear that the situation here does not derive from faulty workmanship by my client. It is also clear, based on the evidence presented, that my client complied with all the contract specifications required by the contracts. There is no place or specification in the contract documents that obliges my client to have gone beyond those specifications to make determinations about the site. It is also true that the tanks were placed within the parameters allowed under the circumstances, that is within 1 to 15 feet from the surface. It is also true that in the contract specifications, provisions, and I particularly refer to the FIDIC conditions, that indeed, under the circumstances, my client is free of any liability, that indeed the assumption of the risk for the site falls squarely to the employer, pursuant to clauses 410 through 412 of the FIDIC conditions, and specifically to provision 17.3 and 17.4 of the FIDIC conditions. And with that, I conclude my summation remarks.
Thank you very much, Mr. Hamilton. Professor Rooney?
Yes, thank you very much. I do have a closing statement. It will be brief. First, I would like once again to emphasize, as Dr. Hamilton did just indicate, that this is a contract whose content is determined principally by the 1999 version of the FIDIC Yellow Book. The principal characteristic of the Yellow Book with respect to this arbitration is that it is a design and build contract. There are certain specifications given by the employer, but ultimately it is the contractor's responsibility to design and to build the work. We have heard from the testimony of Ms. Lindsay, and is also shown by the contract itself, that the question of whether an examination should have been undertaken with respect to the appropriateness of the design given the soil conditions of the work was something that the contractor was not absolved from in the contract. There may have been discussions, but at the end of the day, it is the wording of the contract that governs. The particular contract, the particular conditions of the contract did not absolve the contractor from conducting an appropriate examination of soil conditions. What we've seen from the expert testimony is that the contractor in fact conducted no examination, not even a soil bore on the location of the works. There was a general understanding with respect to the soil conditions there that would indicate that it would have been appropriate in the discharge of the contractor's duty that they in fact have done a more complete examination, and in that context would have understood the consequences of the leakage with respect to the taking of the contaminant by the aquifer to the surrounding community and the damage that was resulted. In light of that, we submit that the contractor is in fact liable for the damages that were shown on the slide that I showed to the contractor's expert at the end of his testimony, and that form part of the claimant's plea for relief. And on that basis, ask that the arbitrator find for the claimant and condemn the respondent to pay the cost of $6,212,188.55. Thank you very much.
Thank you, Professor Rooney. I thank both counsel, and I also thank the real-time transcribers and the technical support for the documents. That's Mr. Jesse Francis and Mr. Juan Ortega. That concludes the hearing, everybody. Ordinarily, as arbitrator, I'd adjourn and write an award containing my decision, but for the purposes of the demonstration, I'll just give a very quick decision orally. So in arbitration as in litigation, he who pleads must prove, so that the onus of proof of liability and causation of the claimed losses is with the claimant. There is no counterclaim. Three principal issues arose for consideration: the design of the works, the construction, the quality of the works undertaken by the contractor, and potentially the impact of the ground conditions at the site. Did they affect the works and cause the damage? If so, who carried the risk of adverse ground conditions affecting the integrity of the works? The evidence. I accept Mr. Lindsay's evidence as to the facts that Kitco specified the waterproofing. CCCL did not warrant it, so if it was wrongly specified, there's no redress against the respondent on that score. Was it poorly applied? As a matter of fact, there's no evidence of bad workmanship, says the expert. I accept that evidence. Ms. Lindley described the ground conditions. She confirmed Kitco provided no site data and didn't expect CCCL to undertake tests if they were not necessary, but said that CCCL did not warn Kitco of any implications of not testing. I must say that for a company engaged in the purchase and storage and safe sale of fuel and other chemicals, I consider that it is self-evident that if there is no ground investigation, there could be a risk of unforeseen ground conditions materializing and consequent damage to the works and contamination of the surrounding soil and any water source. But that in itself doesn't absolve the contractor of responsibility, because clause 410 of the contract imposes obligations on the contractor to satisfy itself about the site conditions, and it was not amended or removed from the contract. If Kitco provided no soil investigation, there is no conceivable basis upon which CCCL could have satisfied itself as to the suitability of the ground conditions to support the proposed design of the tanks or methods of their constructions. But on a contract of this nature, would they be considered necessary for tanks just below the surface of the ground? The expert says no, they would not be usual or necessary. I accept Ms. Lindsay's evidence that there was contamination and loss caused to adjoining farmers, but that was due to leakage from the tank. But was that due to leakage from the tank or other causes that are due to CCCL? Turning to the expert evidence to assist, I find that I'm not assisted. It is said that the steel used for the tanks was substandard. It was specified by Kitco. We heard that in evidence. Was that the cause? The expert does not reach a conclusion, safe to say that the desktop evaluation shows everything to be within acceptable parameters as to the design and construction methods. He also gives unchallenged evidence that the contamination could as easily come from other sources. In all the circumstances, I cannot say that even on the balance of probabilities, the claimant has proved its case. The claim is therefore dismissed. Thank you very much, everybody. And that concludes the arbitration demonstration.
Madam Arbitrator,
Yeah.
I think we ask for costs.
Professor Rooney, quickly, can you resist that application?
I think while I think that I'm not sure that I have not seen an application for cost, to tell you the truth, in the record. But assuming that there was, I think that the equities of the situation indicate that the claim of the claimant was certainly not frivolous, and that in the event that even costs were to be awarded, that there should be a reduction of those costs by the fact that, in fact, I think that the claim was valid, although in the opinion of Madam Arbitrator, not completely proven. I would request that the application for cost be rejected, especially because I'm not aware that it is contained in a pleading.
I'm unaware that it's necessary to plead a claim for costs. I think I have the power to order costs under the rules, and in my judgment, costs should follow the event. The respondent has succeeded in its defence and therefore should be awarded the costs of the defence insofar as there is any reduction to be made. That can be made on an assessment of the costs in due course. Thank you both very much.
Thank you, Madam Arbitrator.
And back to our host.
Thank you so much, Karen Goff, barrister. That was very good. The comments that I'm seeing is that they love the role playing, and we see what the process will be like and how it will help in the different elements of arbitration in the different sectors that will need this process digitally. So we move right into it. We're going to have remarks from Mr. Anand Judo, Director of Judo Consulting from the Mauritius. Mr. Judo, are you ready to speak with us? Mr. Anand Judo, over to you. You are still on mute.
Right, is that okay now?
Yes, you're good now.
Thank you very much, Noxine. Very nice to meet all of you, and good morning or good evening, wherever you are in this world. It's actually night time here, so I'm burning the midnight oil, if you can put it that way. I am honored to be present and witness firsthand the launch of iNeutral by JAIC. With this platform, and I believe JAIC is opening itself to the world, which I'm sure that many will adopt this ODR platform. I must here congratulate Dr. Malcolm for this initiative and of course for his resolve and leadership in the field of ADR. I'm pleased to state that Dr. Malcolm is not only a close friend, but a true professional. We met in London sometime back in 2016 for a CIRB event and have since knitted a very close relationship. And I must say he amazed me every time I meet him or whenever we speak. We all know that the COVID pandemic has changed the manner in which people or parties are looking at resolving disputes. And this demand, and therefore, of course, they demand a very reliable platform which meets all their requirements in this pandemic world, especially an all-in platform, which would include a full spectrum of services, such as real-time recording, document production, expert witness, etc., as well as technological feed that we've seen for both parties to put in the case. But however, there are in fact various challenges that lie ahead for any ODR platform. One that comes to mind is how to make the platform hacker-free, and also how to enhance confidentiality of audio platforms. And I'm sure Dr. Malcolm and the JAIC has looked into this matter, and iNeutral will obviously be safe as far as arbitration is concerned. I have, in fact, having witnessed the demonstrations, I note how user-friendly the platform is. So no need to be tech savvy to operate the iNeutral platform. And now, having witnessed or attended, so to speak, virtually, the mock arbitration, I'm amazed at the ease with which technological advancement are included in the platform. Especially, I like the, if it's document only, or if you require a very quick decision, I enjoyed the virtual award by Karen. That was very nice. And I think you've brought all of us to this platform. I'm happy to announce, having discussed the matter with Dr. Malcolm, that I'm looking forward to sign an agreement for the use of iNeutral in Mauritius and certain African countries, not transgressing on my good friend Sundar Raju's revolution to get into Africa as well. But I think it's something that should be shared to the whole world. So on this note, I'm very certain and positive that iNeutral will give parties an easy option of resolving their dispute efficiently, cheaply, and in a very safe environment. Once again, congratulations to Dr. Malcolm and the JAIC and his team for coming up with such an innovative platform. Thank you very much.
Thank you, Mr. Ananjado, and good evening to you, because you says it's night where you are in Mauritius. We thank you so much for your words of encouragement and positive energy. Moving right into Mr. Mark Fulford, who is the managing partner of Fulford Chambers out of Turks and Caicos Islands. Over to you, Mr. Fulford.
Thank you. I adopt the protocol that have been established, and I bid you all a very good morning, good evening, good night, wherever you are. It is indeed a good day for a great launch of something revolutionary, which is iNeutral. I am the managing partner of one of the leading law firms in Turks and Caicos Islands, and Turks and Caicos is made up of 40 islands and keys, out of which only 9 are inhabited. We are one of the countries who are not yet independent and therefore are associated with the United Kingdom legally. They say we are their territory, but in actuality, we are our own territory, belonging only to the people of the Turks and Caicos, but operating under the UK flag. Nevertheless, our justice system follows the common law model. In Turks and Caicos, our courts are run by a new and progressive Chief Justice, Mabel Ajiman, and her able registrar, Renee McLean, who have been working post-haste to modernize our courts. And so to talk about the modernization and how iNeutral fit into it, our court composition is a little like this. We have 1 labor tribunal, 3 magistrate courts, and 4 Supreme Courts. So with our small court makeup to service a population of 40,000, iNeutral can play a great role in the Turks and Caicos Islands. Another important piece of information to note about the TCI judiciary is that since the pandemic in March of 2020, the Chief Justice has passed major law reform to allow the courts to make use of technology to continue the business of delivering justice for all. And this was made possible by either a remote hearing or hybrid hearing, which is a combination of remote and in-person hearing. I say that to say that the pandemic has taught us in Turks and Caicos the urgent need for access to justice to continue despite the circumstances. And turning to iNeutral, our Chief Justice in Turks and Caicos with her admin staff have had the opportunity to be introduced to the iNeutral platform and were quite impressed by the way in which this revolutionary platform fits within her plans for further mobilization of access to justice. From my own point of view, where I sit in TCI as the Director General-elect of the newly established TCI ADR Center, we have seen the power of iNeutral. We have had the very able Dr. Malcolm demonstrate the usage of same, and we can say without a shadow of a doubt that this will revolutionize the practice of law and further develop greater access to justice, not only in Turks and Caicos, but throughout the world. So we endorse iNeutral and look forward to its launch soon in Turks and Caicos, and wish Dr. Malcolm and the JAIC and his team much success. Thank you.
Thank you so much, Mr. Fulford, Managing Partner of Fulford Chambers out of Turks and Caicos Islands. So we're going to go right into our question and answer segment. We have a few minutes, and I will begin by throwing it out to members of the media. If you are there, you can unmute your mics and you can put your questions out. Our main respondents will be Dr. Christopher Malcolm, Ryan Davey, and Jesse Francis. So I now throw it out to members of the media if you have questions. In 5, 4, 3, 2. Chris? No? 1. All right. Well, I have questions in the Q&A forum, so I can throw them out, and Dr. Malcolm, Brian Davey, or Jesse Francis can answer accordingly. So let me start with the first question. It's coming from Ms. Lisa White. Will the dashboard appear different or the same for arbitrators and persons or entities seeking arbitration services? I figured that would be Ryan, I assume. Would you want me to repeat the question? Or
Are you hearing me? Are you hearing me, Roxine?
Yes, I'm hearing you now.
I think the short answer to that is that the way the platform has been designed, there are multiple forms, as Ryan went through, and you will have different levels of access for persons. So for example, the claimant will never need to have, nor will a claimant have access to all the forms that are necessary, nor will the respondent for that matter, nor will the arbitrator or mediator or anybody else. So what will happen is that the moment you start a matter, there are some basic forms, the requests and so on, which will be in their blank form, be available. But the moment they become completed and a part of the case, the court, the file, then they become accessible to all persons who are in it. So it depends on the level of access, and it depends on the level of need. That is the way that the platform is designed to work.
Okay, thank you. All right, we're going to try and go through as many questions as we can. An anonymous attendee asked, how does one get registered as a possible arbitrator with iNeutral?
Well, there's no, iNeutral is really a platform that is capable of being used by various centers. In this instance, we're speaking about it in the context of the Jamaica International Arbitration Center. And if you were to go to the JAIAC.org, you will see some of the panelist requirements there, setting out how persons may in fact qualify for consideration to become members of our panel.
All right. Moving on, given the analytics, will there be a default period within which disputes are encouraged to be completely resolved, bearing in mind different levels of difficulty for the matters?
The analytics, and perhaps I could answer that. The short is that we always encourage speed, but the beauty about ADR is that it is a process of mutual agreement between the parties. So the parties, notwithstanding that, if you go to the JAIAC rules and you subscribe to those, which is what is used in this, again, in this particular context that we're looking at, the rules themselves set out time periods for filing, for responses, and so on. And if you, for example, try to go under the fast track rules, there are provisions there as to the time period within which a matter should be concluded with a decision included in that. But even with that, the parties can themselves, by mutual consent, agree to those adjustments to that time and expansion of the time and so on. So there are always provisions there. Of course, the ideal is to ensure that matters do not drag on forever. However, as I said in another context yesterday, the general understanding is that justice delayed is justice denied, but it is also true that justice hurried is justice buried. And one has to be careful that you do not, for the sake of expediency, forget that you have real lives and real people and real situations to consider, and that you should take appropriate steps to ensure that decisions are arrived at after proper consideration and not necessarily simply to meet a timeline, because that is a dangerous position to always adopt.
Thank you. Ms. Tanya Ralph asked, technology is permeable, and with everything going on these virtual days, I'm sure hackers are working just as hard as we are. With that said, can you guide us without revealing too much? How safe will confidential documents be once they're uploaded on this platform?
I'm sure Ryan can answer that from the technology platform
Right.
side as what has been done.
Ryan? Are you there?
I'm not sure if he's having some issues. He's in New York at the moment. He's not even in Jamaica. So if there's a technology issue, sadly it's in the New York area. But the short is, if I may say that though, a lot of measures have been taken to ensure that there's proper encryption, and a lot of standard and even beyond standard measures have been taken from a technology perspective to ensure that confidentiality is maintained and documents are secure. I am not myself a technology expert, so I could not go through the technology aspects of it, but I can assure that a lot of effort has gone into ensuring that security of document is provided for.
Okay, will the transcript be made available immediately after every sitting? Can you answer that, Dr.?
Well, there are two things that depends on several things. One is that transcription service is an add-on, is an add-on service, not necessarily a standard service. And secondly, as to what you get in terms of real time, the real time report, if you agree to getting it, and because as I said, it's an add-on service that you would add on to the standard features that are provided. But the real time is that you get it and would ordinarily agree the period within which you will have it. But the ordinary and in standard way is that you will get the transcript by the end of the day's proceeding, albeit typically in a draft form and within a time period agreed. You would then get the edited version of it, which has to be agreed with the parties for accuracy. So it is all about what the parties are prepared for. And that, of course, comes down to affordability and what the parties are prepared to pay for. If you want something which is really fast and immediate and everything else, then you do what happens standard, which is that you have a real-time reporter taking the notes as happens, somebody else in a back room somewhere who is editing as they go along. So it depends on what you're prepared to pay for because of the add-on nature of it.
All right. Anyone else in the chat has any other questions? Want to raise their hands? Because a lot of the other questions, Dr. Malcolm, are technically oriented. How do the disputes be as to authenticity of material be displayed electronically, how they will be handled?
Well, that Jesse is on, and Jesse can answer that, actually. Jesse can answer that aspect of it. Jesse?
Yes, and can you just repeat the question, please?
How will disputes as to authenticity of material displayed electronically be handled?
Okay, so basically, when the files are uploaded to the JAIAC website, then, once the parties agree that these documents are true and in fact the original documents, then, well, firstly, both sides can have their set of documents. And then if there's a dispute there, then what the claimants can say, well, these are documents we have. The respondents can say, these are documents that we have. But basically, we're going to go by what is actually uploaded to the JAIC website. And then once they ask us to present either claimants' document or respondents' documents, we'll go ahead and present those. For example, you might have a report from the claimants that does not have some of the exhibits attached, but then the respondents have a report plus the complete set. So in that case, we will either project the claimants or respondents depending upon the request.
And if I may just add something to that, Roxy, the fact is, by the time you get to a hearing, which is where the documents are exhibited, By the time you get to that point, all documents that are made, the arbitrator would have already, for example, let's use an arbitration, would have already made certain orders indicating that the only things that are able to be displayed are documents that have been agreed and have been approved as authentic, meaning you would have had disclosures having been gone through and everything else. So the possibility of a document being displayed that has not been agreed, in fact, if it were to happen and counsel does not immediately object to its presentation, it would be counsel who has certainly not done what he or she should have done by way of preparation. Because anything being displayed is what should have already passed the test of authenticity and passed the test of having been properly admitted into the proceedings.
Okay, thank you so much. I know we've gone way over our allotted time, so Dr. Christopher Malcolm, I'm going to throw to you, Secretary General of the Jamaica International Arbitration Center Limited, to talk about the way forward as we get ready to conclude this event.
And thank you very much. And bearing in mind the time, I will accept everything and be thankful for everybody who is here and the participants and everybody and for what has happened thus far. I'll say this much quickly. The way forward for dispute management, and I like that term rather than dispute resolution, which is really an aspect of it, is a recognition that the world has changed in terms of how we look at disputes, in terms of what people are expecting, and the recognition as well that going forward, we are going to have to rely a lot more on innovation and hybridization so as to serve the best interests of the various publics. And we have to bear in mind as well that there are persons, real persons with real lives, having real outcomes that they are depending on to make valuable life choices, and also very often to determine sometimes whether their businesses sink or swim and so on. And I think as we are looking forward in terms of expansion and what we're doing, the question is, how do we become more accessible? How do we ensure that things are made cheaper? How do we ensure that results are faster? All of those are the things that we're going to do. And as I'm saying, just to quickly add that this is the first phase of a development that we're on, which is going along the route of something being appended to a website. The next phase, and in very short order, over the next couple of months, just watch this space as they sometimes say, we will be rolling out our mobile app, our application, which will be a downloadable application for your smartphone and whatever. So that app, which is accessible via whatever method, is available. And just to add, of course, at the moment, this iNeutral, which has been designed, is already accessible and designed to be accessible by mobile phones, by computers, by whatever you have. It's available, but we're going to be going a step even further to make it much more accessible. And we're, of course, putting in all the backends we can, and by way of further expansion, ensuring that we have appropriate relationships across the globe that can make this much more accessible and much more available for use. And again, thank you for the time. I know we're, as you say, well over time, and I don't want to stay for much longer. But thanks for everybody who's been here and just watch this space is what I'd say, because there are a lot of things to be rolled out.
Thank you so much, Dr. Malcolm. iNeutral is now up and running, everyone. It's a unique technological innovation in online dispute resolution with full spectrum application capacity for dealing with domestic and international disputes. Special thank you to Honorable Delvar Chuck, Minister of Justice, Jamaica, Sir Patterson Cheltenham, Chief Justice, Barbados, Dr. Christopher Malcolm, Secretary General, Jamaica International Arbitration Center, Dr. Professor Sundur Raju, President, Asian Institute of Alternative Dispute Resolution, Mr. Lloyd Diston Jr., President, Jamaica Chamber of Commerce, Ms. Nicole Liverpool Jordan, Deputy General Counsel, Caribbean Development Bank, Mr. Ryan Davey, Web Developer and Tech Reviewer, the mini arbitration team of Ms. Karen Gupp, Mr. Calvin Hamilton, Mr. John Rooney, Mr. Jesse Francis, Mr. Jade Lindsay, Mr. Juan Ortega, and Miss Sharika Lindsay. All our esteemed partners, Mr. Marlon Griffiths, Web Developer, Ms. Nordia Henry, Administration and Logistics, Dr. Dawkins Brown, Business Access TV, Mr. Johan Dawes, and Hype TV. You, our participants, or producer, Mr. Shannondale Reed. We implore you to manage or resolve disputes in a cost-effective and timely manner and use iNeutral and make it easy. It has been my pleasure to meet you all and to host this event. I've learned so much more on the importance of arbitration and the very needed role it has in our society. I ensure you to encourage others to go to the website, ineutral.jaiac.org. I'm Roxine Hickel of Jamaica's Observer, the Edge 105 FM. And from Jamaica, I say to you all, good afternoon, good evening, good night, wherever you are in the world. You all take care and be safe.